What's a subpoena in a criminal case? If you've received a subpoena in a criminal case, here's what you need to know. Subpoenas are of two types. There are regular subpoenas and subpoenas duces tecum. A subpoena generally means that a court has ordered you to appear in court at a specific date and time. A subpoena duces tecum means you're being ordered to appear in court with something. That something may be documents. The something may also be a minor child, because children cannot be subpoenaed themselves to be in court. It has to be a subpoena duces tecum to the parent to bring the child. A subpoena has to be followed. If you don't comply with that court order, a judge will have a writ of attachment issued. That means he will order a sheriff to come pick you up in handcuffs, arrested, and brought to court to answer to why you did not appear. Your testimony will still be required in court, and you might face contempt proceedings from the judge, meaning you could be sanctioned for not appearing and complying with that subpoena. So if you receive a subpoena, you absolutely have to be in court. There's not an excuse for having to go to work, that you had other plans, that you had family obligations. It is an order to be in court. If you receive a subpoena that you believe you cannot comply with, you need to notify a criminal defense attorney as soon as you receive that subpoena. In other words, if the subpoena duces tecum calls for a library of documents to be provided in 2 days, and you simply can't gather that, you need to notify an attorney as soon as you get the subpoena, and not wait till the day of the court proceeding to notify someone that you can't appear. That attorney instead can notify the court beforehand and ask for a hearing on whether or not you need to comply with that. Similarly, if travel or other difficulties would prevent you from being in court on the said date and time, the attorney can appear for you again before the anticipated court date and try to get you excused. You should not think that simply calling the court or not showing up is somehow going to absolve you of having to appear. Hiding from the subpoena is also not going to help, because once the writ of attachment has been ordered by the court, a sheriff is essentially mandated to find you. Whenever they find you, place you under arrest and bring you to court. So you don't want to risk that. If you receive a subpoena, plan on complying with it. If you can't, contact an attorney immediately. If you're facing that type of an issue in North Texas, give us a call at 817-203-2220.